Right. Thank you so much, everyone, for joining in for this week's Let's Strategize series. We have our very own legal counsel, Smruthi, who would take you through the nuances of real estate and everything which goes in and around real estate in general. Smruthi, over to you.
Hi, all. Great to be doing this with you, Sudarshan. So shall we start?
Yeah.
Okay, so today we are trying to look at the basics of real estate due diligence that you would have to do when you're evaluating immovable property purchase. And we will try to cover the very basics of this. So when in the first slide, we're talking about what are the facets of a due diligence. So when you are doing a legal due diligence of immovable property, you would cover it under these main heads. Here we speak of title, survey, revenue, disputes, and compliance. Let me go into each of them in very, very less detail because that's what we'll be capable of doing, because due diligence is generally such a detailed process, and you will have to be so diligent in going through each thing, because every little paper, every little document or record that you are verifying will have can have huge impact on what title of the property is. So under title, what you look at would be the previous owners of the property, and you generally go into market standard, you go into like 30 years history. The look back period is 30 years or 12 years. In some cases, you can do a limited due diligence or you can do a detailed due diligence. 30 years and 12 years is linked to limitation periods. This period of look back and this period of due diligence will basically help you ensure that there are no existing rights over the property other than what you have seen in your title records. Now, title records are the previous owners, and they will tell you what charges might be there, what encumbrances might be there, etc. In this, you would look at your EC, your latest title deed, and your EC is the quickest fail-safe. Even if you have not gone into a very detailed due diligence at the first stage, the EC will let you know what will give you a pretty good idea of what registered documents are there, what charges might be there, etc. Next, you will look at survey documents. These documents basically lay out the survey of any property. It could be back from your village map. Now, even if it is a city property, it would have come from a survey number of a village. And when you trace it back 30 years, you will look at your village map, etc. It will let you know if there was a Raja Kaluwe there, etc., which buffer zones still have to be observed, right? So that will help you make better planning of what you would do with your property, what construction you could do, etc. Apart from this, survey documents will basically coordinate with the title documents and the revenue documents. Here, when you look at all of these three together, they will reflect each other. For example, your survey document will show who the owner was, and that should coincide with what your title says. And your revenue documents also. Your revenue documents are basically your khata, your tax paid receipts, etc., which are and if you go into detailed due diligence, there will be many other revenue records that you'll be looking at, depending on which geographical location you are in. For example, in your Karnataka, it would be called Khata. In Maharashtra, I believe it's called Satbara. You have your Patta, Chitta, Dangals in Tamil Nadu, etc. So these are the records that the revenue department of the state keeps, and they are basically keeping track of the ownership of the property, as well as what taxes have been assessed and such things. These should again coincide with what your survey is reflecting and what your title is reflecting. These basically will give you a very good idea of how title of that property has flown. Apart from this, very important to note is that you are, of course, Indian real estate, and we are always wary about what disputes are existing, litigation that can take years, and just the thought of litigation breaks us into a sweat. So when you look at disputes, things that you could do is that a good public notice sometimes helps. You issue a public notice with a good 10-15 days in the local area newspaper, local language, in the English newspapers. It will at least give you some sort of sense in case there are any claims existing with respect to the property. But apart from that, litigation search is what is conducted. Since most litigation records in India are not yet computerized, these will be majorly hard copies, but litigation searches are conducted by various services. Even your lawyer will go and do a litigation search for you in every court, or they can also do a litigation search on with the higher courts, etc., online. So this would be what a dispute from a dispute angle, what you'll be looking at. Compliance is one more thing that becomes very important when you're looking at constructed properties. Now, when you're going to purchase under construction or completed constructed properties, it's very important that the building has to be compliant with the statutory requirements and the regulations of that particular planning zone, authority, etc. Now, if your BBMP has not given you an OC, it would mean that you did not get an OC because you were not compliant with the regulations, with the setbacks, if there were deviations, etc. That those are some of the reasons why you wouldn't get an OC. So getting an OC would be a pretty good standard of knowing that you have complied, the building is in compliance. Apart from that, under construction is usually was usually a very risky proposition, but then you got RERA, which also talks about what compliances have to be, what regulations, what reportings have to be done by an under construction property, what the developer is liable to do. That RERA generally it came in to protect buyers. So RERA is very notorious for being biased towards buyers and not towards developers. It put developers in a lot of soup. There was a, as you know, with how the news went, and the industry itself faced a lot of issues when RERA came in. But that was because there was a lot of non-compliance, there were a lot of deviations, and all of this came to end with RERA. But RERA again governs only commercial and residential. So when it comes to industrial, you will have to again go in depth into what compliances, what separate documents have to be looked at, etc. So that is
Just quick
very
thing, Smriti,
top
like
line
you
overview.
mentioned
Yeah.
about occupancy certificate, etc. But for different states, it can be different. It can be called completion certificate, or it can be different things. But
Yeah.
is this advisable as a question that if the property hasn't got an OC yet or a completion certificate yet, is it advisable for one to consider investing into the property? What are the risks which one can have when they invest into something like
See, this is a question that you should look at from various levels. Now, if you're looking to acquire, say, an apartment, it might be like a eight apartment building, say, for example, and it does not have an OC. There might be a lot of reasons why there's no OC there. Sometimes it might actually point to deviations in compliances. Sometimes it might not. It might just be that the developer didn't do it and now it's too late to do it, etc. The Bangalore is filled with non-OC buildings. So then if a residential purchaser was looking at OCs, they would really not be purchasing much. But yeah, OC and completion certificate is definitely important, especially when it comes to commercial buildings, etc. The authorities have a lot of power when it comes to non-OC buildings. Basically, if you do not have a completion certificate or an occupancy certificate, the building is not viable to be occupied. That's the bottom line of it. So
quick question?
definitely,
Can a government authority even demolish the property?
yes. Eventually, yes. Again, now, as you know, Karnataka is coming up with regularization norms. There is the Akrama Sakrama regulations that are coming up with. Again, these are all to avoid such extreme scenarios where the government can demolish.
Okay, awesome.
Shall we move on? This is a brief about what to be mindful of. Now that you have listened to what are the basic proponents of legal due diligence and what are the basic areas that we covered, what you could be mindful of when you are purchasing property are these things. Now, when you go into a due diligence, your lawyer would obviously cover all the bases that we spoke of, and they would do in-depth job. But what you need to be cognizant of are these things, basically that your due diligence is complete and is reliable. You do have to sometimes invest the money and effort and time it requires, the legal due diligence, because we know how rushed timelines are, how much in a hurry people are to close deals. But please do not ignore the due diligence. Do give it the time and effort that it requires. A technical due diligence is also extremely important, because once you have gone ahead and made your purchase, uh, you do not want to encounter unforeseen expenses with respect to, say, for example, there's a deviation that you have to now uh, regularize, because, for example, your property is not getting tenanted because there are deviations and that need to be regularized, etc. So in such events, you definitely need to do a proper technical due diligence. That does help. Now, your technical due diligence will always save you from such things, from unforeseen effects of, say, non-compliance or building construction itself. You don't want to be purchasing a pre-tenanted property or a under construction property that might tomorrow give you leakages and seepages, which maybe will be a lot of time and effort consuming to rectify. You have to ensure that your documentation and the structure is kosher. That is that uh, if you're so the documentation and the structuring depends on what kind of deal, the commercials of the deal, the realities, the practical aspects of the deal all the time. So of course it varies widely from deal to deal. Now, if, for example, you are doing the due diligence and you want to make sure that your seller has accounted for certain things before you complete the deal and complete the purchase, then you would go for an agreement of sale, give an advance, make sure that the conditions precedent that you would impose on them are fulfilled, and then go on to complete the sale, for example. Now, the documentation should be kosher in that sense. You should make sure that you have structured it in a sense that you provide for all the practical aspects of this deal. Pricing must be realistic. Now, when we talk about pricing must be realistic, we must talk about the guideline value, and we must talk about how these are ascertained. For example, when we at Strata have to ensure that pricing is right, because we are stitching a deal or we are enabling a deal on behalf of investors and not on behalf of ourselves, it becomes all the more important, so of paramount importance, to make sure that we are not losing out because of what a broker said or because of what we heard to be the market valuation. So there are ways to ascertain what pricing should be realistic. You could go to the guideline value as a baseline. Of course, there is always a big gap between market value and guidance value, but the guidance value will give you some sort of starting point, at least, at the very least. uh, Pricing, there are definitely services that give you, like, for example, Zapkey would give you what the last 3 transactions in that area were. Strata would rely on PropStack data. So big data is helping in a big way in solving for such issues. Proper indemnities are secured. So indemnities, so when you are doing a real estate transaction, indemnities are what could help you in future, because once the deal is done and the title has passed, then you cannot go back to your seller in the real sense, in the practical sense, for anything. There is only so much that you could have uncovered in a legal due diligence or in a technical due diligence, and there are still some outstanding issues. For those balance issues that you might face, for that eventuality, you have to ensure that there are proper indemnities in your documents. There's something that maybe you could go back to, those are something that if enforced correctly under litigation in a court of law, then you have a shot at getting what is fair. Stamping and registration requirements. Stamping and registration of documents is very important because they go to the validity of a document. If a registrable document is not registered, it would be invalid, your whole transaction would be void. So you have to look out for what are the stamping and registration requirements of all the documents that are in your transaction.
Again, which is why I think one of the very important things is knowing the guideline value as well, because sometimes it's critical. Sometimes there's a good chance that the market value is below the guideline value.
Exactly.
You do your assessment and you say, hey, this is the stamp duty I'm going to pay, which is of my purchase value. But sometimes when the guideline value is higher, your stamp duty is also higher,
yeah.
Also at the same time. Right?
Yeah, definitely a good thing to do a pre-research on all of that, so you can provide for all your expenses. Now we can talk about pre-leased properties, and when you are entering into transactions that are pre-leased, you would have a tenant already in place. This tenant could be a lessee, this tenant could be a licensee. So there are various tenancy arrangements that that your seller could have with the tenant. So you have to ensure that you know what type of document is executed and what rights those confer on you. There are differences between a lease and a license, leave and license agreement. There are differences between a lease and very little difference between a lease and rent model, but leave and license and lease are definitely very different in principle. So you have to ensure that you know what rights you are getting into in that pre-lease property transaction. The lease period, the lock-in terms, of course, apart from the basic commercials of what you would look at, that is the rent, the security deposit, and apart from all of that, it becomes very important to look at these terms. You have to look at what the lease period is, what the lock-in terms are, because the lock-in in effect bars the tenant from exiting the property for that period, and that will give you a good sense of what your cash flows would be and what your next 5 years looks like. Apart from this, you will also have to look at whether there are provisions for force majeure, whether there are provisions for, now force majeure is the new buzzword ever since COVID blessed us with its presence. So force majeure is a pretty wide provision where you can provide for a lot of things. Now, force majeure would be any situation that is an act of God, that is out of the control of the parties. In a force majeure situation, you should look at what the tenant can do, what their rights are, whether there is a rental holiday, whether they have a termination right, how long you have to fix the issue. If there is, say, for example, if the force majeure is like some sort of issue with the property that makes the property uninhabitable. In that case, you would have to look at what your force majeure timings would be. If you have 15 days and you have to renovate a section of the property, that would not be practically viable. So you will have to look at these provisions and maybe renegotiate if possible, where possible, to make sure that you're getting into the best scenario here.
Just to add one point, I think one of the like what Smruthi mentioned as a buzzword it is, but COVID provisions are the new separate sections which are a form, which are a part of all the lease deeds itself, where it says due to COVID, if the tenant is not able to occupy the property, then those respective days will be rent free. Uh, if I'm the tenant, I would also expect the same, but most of the cases I'm the landlord representing our investors as such. So we push back and we say, if there's a governmental lockdown because of which you can't, just because you couldn't come, that doesn't mean you stop paying us rents. But if there is a government lockdown, we absolutely understand and we're fine. And this is ideally the new norm right now, which is what the industry is also following. So something to look out for. It's completely evolving, and I think there'll be a lot more evolvement until we completely get out of this pandemic as such.
Yeah, so force majeure, again, COVID is the highlight now, but also provides for a lot of other things, and you have to ensure that your tenant does not get a free termination right, which might be unfair in so many situations. Now, rental delay penalties are another thing that you would have to look out for, if because the whole basic point, the essence of getting into a pre-leased property transaction would be the rents that you accrue. If you have LRD and all of that, especially, then it becomes very important to see what kind of provisions are there that guarantee you timely returns, timely rentals, that mean. So you could see generally what rental delay penalties would be a percentage for the period of delay. But there are also situations where, say, the rents are in arrears and the delay penalties don't kick in for 3 months. That could be a scenario, but your security deposit covers you only for 2 months. Then you have a month of exposure there. So it becomes very important to look at provisions like that. Attornment, again, is very important, because attornment is it is a legal it's a legal process. Generally, you do not have to it is guaranteed by the transfer of property itself. Along with the transfer of property, your attornment happens, but it is always ideal to record this in a attornment letter or an attornment agreement, and that should generally have the you stepping into the shoes of the old lessor, your responsibility to refund the security deposit, tenant's responsibility to pay to you now instead of the old lessor. And usually you could get an indemnity for whatever has happened up until you stepped into somebody's shoes, because in a pre-lease property sale, it is you taking on somebody else's obligations for that period onwards. So you could maybe put in an indemnity there for anything that has happened until then, any dues that exist between the tenant and the previous lessor. Termination rights is another very important thing. You should ensure that neither party, to be fair, in a draft, in a lease that is without prejudice to either party, both the parties have fair termination rights. A tenant maybe could ask for termination rights if a force majeure or if any act of God happens. This is an example that maybe makes the property completely unusable for them. But up until then, there should be some sort of cure period. There should be some sort of space for the landlord to also react and maybe cure the breaches that have happened. There should not be a termination right with the lessor if the tenant has not paid 1 month's rent or 2 months rent. That would again be not fair on the tenant's side. So termination rights is important. It is obviously varied from lease to lease, from deal to deal. It depends on how you have negotiated that lease, but that's another thing to watch out for.
So I just want to add a couple of things, like especially during lock-in terms to review, right? One of the very critical things is to see, is this just a paper lock-in, or is there a lock-in that in the event you terminate during the lock-in, the tenant is liable to pay the rents of the entire duration? of the lock-in which is agreed upon, right? So many companies craftily write it in a way where it's technically just a paper lock-in and the tenant has the ability to keep moving out. So this is something which we very proactively look at, and if those provisions don't exist, two options: we either don't buy the asset because ideally it's without a lock-in for us, or the second is we renegotiate and get those lock-in provisions tighter in a better way. Right? So this is something which is critical. Again, points which termination rights, which Smruthi was mentioning, um, things which are again very critical is to see what are the other grounds in which termination can happen. Like one of the grounds is, let's assume, because of force majeure. You had to redo the property, or because of any reasons, when the property went defective, or there's some water leakage or whatever it is for that matter, which can happen, and it's real estate, anything can happen. So point is, there should be a cure period, and if in the cure period, if you as a landlord or as a owner have not cured that, that can also be a ground for termination. They can just pack up their bags and leave as well, right? So to ensure you safeguard, you need to ensure that there's enough cushion, enough cure period given, and things around that as well. And just the last point on rental delays, uh, it's a great provision to have, like what Smriti mentioned. Imagine you have just a 2 month security deposit, and there's a provision which says up to 3 months that is okay if he delays his rent. You're exposing yourself by 1 month of rent. Ideally, if he leaves after 3 months and doesn't pay, your 1 month of rent is lost. So one of the things which is critical as part of rental delay penalty, see if there's a delay by a week, 2 weeks, it's fine. As such, it's part of general business, cash flow issues, whatever it is for that matter. Otherwise, very important to see what percentage of interest also which you can claim on board and start generating. So all these things, there are enough and more precedents in the court of law with respect to the implementation of these respective provisions, and something why these are very, very important points which you need to look at before you acquire any pre-leased assets. All right, moving on. Cool. So let's talk about our platform itself, or what new industry category which we have created as such. And it's what is very important for you guys to understand how this works, what is the model in which one has operated, how everything. So important for you to evaluate, because we heard from our investors, and obviously we keep tracking. There are multiple other platforms who are not just doing real estate, doing multiple other asset classes also, where they are democratizing the whole asset itself. It can be for asset leasing, it can be a bond for that matter, it can be an invoice, it can be real estate, it can be infrastructure assets in tomorrow, anything and everything where investors can come in and acquire the assets in a better way, right? So one thing which is very important is understanding the legal model used in the asset. It's critical. We follow a private limited structure governed by the Companies Act, etc. Very important to understand, okay, what is the tax leakage? If in the event when we're looking at exiting, how easy is it to exit, or how difficult, what is the tax during that aspect as well. So very important to understand the whole legal model. We've thoroughly studied the whole LLP model and the private limited. Clearly, LLP has a lot of flaws, which, unless the act does not evolve, which is a very new act in general. Companies Act is almost 60, 70 years old now. The idea is to keep seeing precedents of what are the other provisions which can be. One, any of our investors who are attending, please go through the SSA which you sign and see the provisions we put in, right? We've also evolved. Lots of investors have come forward and given us great feedbacks, and we've amended those things as well. Again, to ensure inch by inch, every investor's interest is protected to its maximum interest. Second, very important for y'all is to see the track record of the platform. Look at public records of the previous offerings, where before you decide to invest as well. You're not just investing into the asset, you're investing into the platform's capability to even manage. So it's important for you to see, okay, who's the team which is running the entire show? What's their backgrounds? How well have they done? Do they have any institutional backing? Who are the law firms with whom they're working? Going through certain legal documents. Whether or not you're putting 25 or 50 lakhs, it's hard-earned money, and it's important for you all to read through the legal documents, which we as a platform or any other platform would provide before you decide to invest as well. So it's great to be well aware. Yes, we take care of all the interests as much as possible, but whatever said and done, as an investor, we always recommend you to feel free to ask any questions, review all the documents, and come back. They're very savvy investors who do a lot of research, come back and give us a lot of insights on how we can do better. But these are things which is also important for you to check before you decide. So just don't invest because the opportunity is great, but please look at all the other parameters to do it, because it's not just buying the property, but you're buying into the entire platform, the team, everything's capability to keep serving you with the best of its interest, with the whole customer experience altogether. So very important for you all to know about it before we get it. Great. So we'll just start taking questions from all. Whatever questions people had, happy to take for everyone. Smruthi and I will keep answering it. So we have a question, is what are the kind of technology you guys are putting in to automate your legal documents and other vetting processes as such? Unfortunately, the business is such where every city has, I mean, honestly, you have to be a PhD to know each and everything, because the laws are so different in everything. So in terms of automating, everything is very difficult. But we follow our rooms, where our data rooms, where all the documents get stored, which is where from there we plug in to the dashboard of the investors, where they can track their documents in future, etc. as well. But more than anything else, there are platforms like what we have partnered with called PropStack. For residential, there's Zappy and Prop Equity, and multiple other platforms which you could use to even evaluate those things. EC nowadays in multiple states is something which you can buy online as well. Like in Karnataka, for that matter, EC can be done online, where you can just put in the details of the asset, and you'll automatically get the entire encumbrance certificate as well. So encumbrance certificate gives you who the previous owners were of that particular property as well. That's something which can be done. Guideline value can also be found online, which also we do it. But again, if there are assets which are about, say, 7-10 years old, many cities, the SRO might not have updated those documents as such. So unfortunately, for legal in general to be completely automated, the government has to invest into those things before we could do. But yes, from a company standpoint, as technology, as a company, we implement a lot of things to ensure that our entire process becomes seamless. One of the core things is the way we use digital document signatures, templatizing everything, productizing everything, so that becomes a very seamless experience for the investor as well, and for us to track each and everything. Smruthi, do you want to add any point?
So if not although we have not been able to automate due diligence process in a big way, but we have automated the remaining portions of how we handle property documents, how we make sure that these are available to our investors on their dashboards, how we give updates on the latest tax pay receipts and all of that. So yes, being a tech company, we have solved for some piece of that puzzle.
Yeah, we keep getting lots of feedback from our investors from time to time. In fact, we had one of our investors, late in the night at 10, he said, I want to give you feedback on multiple things, because I look at you guys more as a retirement product. And it's obviously overwhelming to hear that, but at the same time, it's critical for us to ensure we match up to your expectations and try working. So team is relentlessly working to ensure that the experience gets better. But yeah, legal front, we're hoping government does a lot of stuff. One thing I think Andhra Pradesh government is implementing blockchain into its assets, or rather I would say they're digitizing all the land records. Now that's a fantastic thing to happen, because the whole title in real estate is all title only at the end of the day. And if that is completely digitized, where you can even start getting everything online, is going to be a game changer. It's maybe not in the next 1-2 years, but I think 5 to 10 year vision, I believe India would be completely digitized in a way altogether. In fact, to a point where I've heard that they're even trying to boundary the entire land, the boundaries with Google latitude, longitudes as well.
Yes, that's very efficient actually.
That's something which is getting worked on. Great. We have next question. Can rental terms like COVID, force majeure, rental arrears be renegotiated during the purchase of a pre-leased asset as such? Yes and no. Purely depends on the flexibility of the tenant, for that matter. But at the same time, these are certain preconditions you could put to your landlord from whom you're buying the asset, or the seller from whom you're buying. Because when you're buying, and obviously he has a relationship with that tenant, he could call them up, have a chat, or rather connect you. Like, at least we always meet the tenants before we acquire the property. So if there's any such provision, we talk it out to them, or make the seller have a chat, because we just don't have the relationship yet, but they do. Certain things sometimes work on relationship, and things can happen. But yes and no, it's very subjective. Also, sometimes the tenant can take advantage of that and say, okay, if you want me these provisions, you give me something else, give me some
Yeah.
rental escalation waiver or a rent waiver,
No, the
whatever.
key is to incentivize the tenant to give you some terms that you might want.
Yeah.
It's yeah. So it's key to identify what is a good trade-off for what you want.
Awesome, great. We have a next question. How would the conflict be resolved when 75% majority stakeholder consent clause gets kicked in?
So Gitanjali Sharma, is that the question that you read? Yeah.
Yeah.
So Gitanjali, this is not a conflict that can be resolved if majority shareholders of a company have voted in one matter. The minority will have to go along with the majority decision. If you are in the 25%, how would your interest be preserved? Now, you have to understand that in this concept, in the concept of a fractional ownership of property, it is the entire investor base. It's all the shareholders of that company that own the property. So the majority does get a valid right, a legitimate right to take a decision on what happens to the property. When you are in a real estate investment, you do not want to be stuck with trying to get 100% approvals on everything, because there is no way that 180 people would agree on one matter at all time, right? So it is good to have this mechanism to go with the majority decision. There would be real democracy in your ownership of property then.
And one of the things which, as such our platform is solving for, right? Earlier, people used to buy like 100, 500,000 square feet in the same, let's say, a 10,000 square feet, right? And in that situation, like what Smruthi mentioned, you need everyone to sign up for, whether it's for selling, leasing, whatever it is for that matter. Here, we solved it through the structure which we follow, made it as institutional as possible, where we take majority. When the majority of taking the interest, it's in the interest of their own money as well, which means they're taking care of the interest. Yes, you may have a conflict with respect to their views versus your views. You may say, hey, they're looking at selling. I still see value in the asset. We can have a much better appreciation. But if majority is taking a decision, we comply with that and we do it. See, end of the day, it's your investments. We follow your guidance, or we guide you for that matter. We advise you, but end of the day, the decision is yours. So if majority say yes, we move forward and we move on. Great. We have a follow-on question. How would Strata preserve the value of the asset 10 years down the line for investors who want to stay long run and benefit from long-term appreciation? What if the property value diminishes? Who does preserve in the long term? So we take care of, we work with teams to ensure that facilities management is taken care of. That's a part of our asset management. We take valuation reports also from time to time, so people are aware of what's happening in around the market as well. But I think one of the most critical things is taking care of the common area maintenance and the facilities management. I think that's the make or break. Another very, very important thing is we never hesitate. We do keep some money in reserves and surplus, but we never hesitate if there is a chance that we can upgrade the property in some way or the other and ensure we get better rentals or the value of our property remains intact at the same time, right? So we would always come back. I think in our agreements also we mentioned that if there are certain provisions like this, we would come back, take your approval and start making these smaller investments to upgrade the property to make it look better. Whether it's simple as painting or changing the facade or whatever it is, but anything which can help uplift the property and in the event return amplifies our rental or capital value, we'll never hesitate to recommend our investors to invest and do it. Again, the same process of getting majority approval and we move forward. All right, we move on to the next question. From Mr. Himanshu, congratulations on creating an industry. I would like to know the fate rentals from properties which were rented out in 2019, given the news of several tenants either delaying or renegotiating the rentals during the pandemic. How did the firm manage that time? Luckily for us, we had only 2 properties before the pandemic kicked in as such. And, it's for us, we are very proud of the fact that we built the entire business in the pandemic itself. One of those other tech stories of bringing a huge customer behavioral change in itself. But frankly speaking, one of our assets where the tenant, a large multinational company, just reached out that they wanted rental waivers. So we own 1 floor and there were about 14 floors in the entire building. We have an association, all the 14, because it's the same tenant as well. a simple request was made. There was a discussion made that the servers were still working from the premises, and if they want a rental holiday, then we have the right to switch off the servers also at the same time, right? So we played a little hardball during that time, and they obliged and continue paying rents. But not all tenants would do that, and on a long run, you would want your tenants to stay there. So many companies, what they did is, for relationship, gave them 2-3 months rental waiver as such. Again, these are important. From a business standpoint, we are passive investors. We want passive income. We don't want to piss off our tenants in the property they are. We're here as partners with them. And we are honored that they're using our premises and operating their business, the growth story of their business as such through our premises. So, having said that, this is how we like to operate as well, if there was an opportunity. But luckily for us, this is not, and all the COVID provisions or whatever it is has been taken care of in most of our lease agreements also at the same time. So we are surpassed 2020 pandemic as such. We're in 2022 itself, and there's obviously a lot of lease agreements which have already been evolved as such. Great. We have a question from Hitesh Setia. How is the TDS deducted by the tenant accounted for? So what we do very smartly is we apply for low withholding certificate for all our SPVs as such. So we have something where it is 0.01% to 2% as such in terms of the low withholding certificate which we have. So the tenant technically deducts a very small percentage. For investors, if there's any kind of a shortfall, we take care of that cash flow so that your returns do not get affected because of this TDS cash flow. Because of the structure which we follow, which is CCDs, effectively all the money gets paid out, by the investors to the investors in the form of interest on a month-on-month basis. So therefore, there's no money left at the company and is claiming depreciation as such, right? So having said that, this way we ensure that there's no cash flow issue to you. But yes, we deduct TDS for you and distribute the rental payments to you as such. But if you again give us your form 15GH or whatever, we would take care of that.
Ruben has a question which says, in case of liquidation of the private company formed for that rental property, how do investors get compensated? In the event of of course, hypothetically, in the event of a liquidation, the assets of the private limited company do get sold off, Ruben, and by the income that the company made, all of the securities would get paid for. So in the event of a liquidation of private limited company, your property would also get liquidated in that sense. There is a question from Sivakumar that says, understood that there is a due diligence in verifying title. There is a chance of a litigation on title ownership even years after the sale. What does Strata do proactively to address the risk? Example, procuring a title insurance, etc. Title insurance, however much we would like that to be a reality, is not that much of a reality in the Indian scenario, because our titles are so complex and there are so many issues that affect it. The limitation periods are also sometimes very subjective, because they might start from the date of knowledge instead of the date of an actual event. There is a lot of leeway for issues of title cropping up. So title insurance is not a very robust or a very evolved concept in India. So procuring a title insurance would not, I don't think that would affect us that much, because even your title insurance will provide for all of your riders and all of your leniences. I do not think that a title insurance in India can effectively protect you against litigation. But in the same sense, as a title insurance cannot really protect you fully, in the same way, your due diligence also might have some sort of scope for issues in future. But litigation would not arise from prior claims, because you would cover all of that, the limitation periods and whatever open claims that could be existing on title in your due dil. If there is any other litigation, of course, as asset manager, Strata would be handling that and spearheading that on behalf of all the investors of the SPV. that is part of our duties as asset manager.
Great. Smriti, there are more questions in the chat. You can see them as well. But
Yeah.
just to add one more thing, which we have done is we take a business interruption insurance as well, that in the event of a pandemic or let's say a fire gets in the asset where we still have fire insurance, etc., and we don't get rents because the tenant is not obligated to pay rents during that period. We take an additional business interruption insurance for most of our assets again, which ensures that no matter what, if there's a thing for additional 6 months to 9 months, we'll continue to keep getting rents as a part of that insurance. So smaller costs, 20,000-30,000 rupees a year as such, but we ensure we take care to ensure the larger interest, we have a lot more to lose in return. Great. We have a question from
Shaunak Mokashi, which talks about, there are a bunch of questions. So Shaunak, the entity that we set up is always a private limited company and has not been an LLP so far. We would love to explore that, but have not yet so far found it very viable or better than a private limited structure. Whether it is freehold or leasehold property, that would depend on the deal. There are certain freehold properties, there are certain leasehold properties as well that we own. For example, an SEZ asset would always be a leasehold property, such things. So we have a mix. LDD report and title clearance all available. Yes, they're always in place before we have even listed an asset. We ensure that all of these documents are shared with our investors when they are investing. Where you have 50% investors or shareholders have agreed for sale, in typical strata experience, the asset sale would be opened after how many years? So every year is when this would be reinitiated. Every year we would look at what valuation is there for the property, because we keep regularly every 6 months getting valuation reports made for that property. So we will reinitiate that poll to all the investors every year.
Okay, I'll take the next one. We have a question from Mr. Bharmal. Valuation of property purchase is done how frequently? We take every 6 months. The next one is going to be due in April. The previous one is updated on everyone's dashboard for them to review. Again, we follow a minimum 6 months period. So if you acquired, and the window is usually either April or October, these are the two windows. So if we bought an asset, let's say in May, then the next valuation will only happen in April because we want a 6 months cooling period before we take any valuation asset. So depends on that. Either it falls in the next window or this window, but 6 months we take valuation reports for all our investments. Great. We have a question. Are the due diligence report generally made available to the investors? Yeah, absolutely. Before you invest in any property with us and post that as well, it'll be on your dashboard, post that. But prior to that, we give a Google folder, which has all the legal opinion copies or other statutory approvals of the particular asset, whatever is made available. We share to investors for them to go through before they decide to invest. We have a question from Ruben. What is the yearly rent appreciation from the properties currently under your management? Again, depends property to property. It can be 4% a year. It can be 4.5% a year. It can be 15% every 3 years. It can be 5% every year. It can be no escalation for 4 years, which is there in one of our assets. We bought an asset with a 9.25 cap and no rental escalation for 4 years as such. So it's completely different asset to asset, but average out, if you have to say, it's about 4.5-5% year on year. But again, depends on asset to asset as such. Great. I'll take the next one as well. All the properties that Strata selects, is there a mandatory clause for tenant to buy insurance, as I've seen as a good example of conflict and fiasco due to tenant insurance clause not in place? So we take insurance for all our assets, whether or not it is mandated in the agreement, in the lease agreement. See, we buy pre-leased assets, which means I can't renegotiate and start putting a new financial obligation on the tenant. The tenant is never going to take it. If there is, we ensure that they follow. In a couple of our properties, there is, and we timely keep checking on them on the due date if they do it or not. Again, 1 week up and down, whatever it is for that matter, things usually come through and we do it. But otherwise, we take the building insurance irrespectively for all our assets. Okay, we have a question from Mr. Dheeraj. May I know how is the value of property protected in case it drops down over time? Unfortunately, there's no such insurance or any kind of risk provision which we can put in where the property price may depreciate over a period of time. Typically, Indian real estate, what I've seen is it becomes a flat market, especially CRE. It becomes a flat market, but it does not depreciate as much unless the building is in a very very bad shape, or there's just tremendous amount of new supply in the market, which is at a substantially lower price than what you're selling. So in commercial, that's not the game. It can happen in residential as such. I can give you an example, like an Embassy Lake Terraces was selling at 4-5 crores an apartment. Good expensive apartments, 10 to 15,000 per square feet. And then L&T came on in the opposite side and started selling at 5,000 to 6,000 per square feet, and close to 2,000, 4,000 apartments. Right now, this is completely stuck because in comparison to this, so now either two options: the sellers who are distressed would come and sell it at a lower price and go ahead, or they would stick on to their price because they paid that price for that. So real estate functions purely on how someone is in need of money and they decide to take a call as such. But typically, we've seen, at least in CRE per se, it becomes a flat market, but it does not depreciate as such. But we can't do anything to ensure that the property can be done. But as asset managers, we, like I said, we take care of upgradation if required. We come back to you that, hey, these are things which we can do to ensure this can happen, or because we are on the ground on a daily basis on your behalf, where we can foresee that this is a market where the either property price can get stagnant or can get dipped a little lower. We'll work towards liquidating before hand itself, right? So these are certain things which take care of as a business as such.
So there's one more from Shaunak. There will always be scenarios, especially over the next 2-3 years, till pandemic is accepted version by everyone. Hence, how do you insulate the risk wherein the tenant renegotiations for rent reduction kicks in, as typically bound by agreement funda may not work due to keeping tenant on long run, but this does affect me as an investor. So Shaunak, you must consider this as if you are going to own real estate. So there are always going to be the same risks that come with ownership of real estate, although reduced to a great extent because you already have an asset manager that is looking out for your interest, for the upkeep of the property, also for the due dil and all of the procedures of the purchase of the property and maintenance. So as Sudarshan already said, we have to keep an open mind. We will most of the time be able to negotiate for non-reduction, or negotiate for the best case scenario, even if there is a reduction. But like I said, you have to look at this like how you would own a property, and unforeseen situations are always going to be part of that. The next one is from Naveen. Congrats and all the best to Strata. Can you explain how easy to exit as an investor? It is important on such time. So there are various liquidation options on a Strata investment. And it is easier than exiting a real estate investment any day. You would exit by sale of your securities, either on the secondary market, where Strata would also help you to find a purchaser, or you would exit in the end after the entire shareholding of the company has decided to liquidate the property. So Darshan, you want to add to that?
Yeah, I think one very important point, which is for investors, is that first, please understand this is real estate at the end of the day. It's not gold that you can get your liquidation tomorrow morning when you want to. And if that is the mindset you have, then clearly real estate or our platform itself is not recommended for you in general. But having said that, this is a minimum 3 to 5 year kind of an investment. I've been very vocal. If you have a 1 year, 2 year investment mindset or a time frame where you may need that money in the next 2 years, I would definitely not recommend you to invest on a platform at all. Because this is not a part of the wallet share we want. This is a long-term investment. You're not here only for rental returns. If you're here for rental returns, there are enough and more products in the market, whether it's bonds or whatever, where you can invest. It's not worth the liquidity risk which you're taking in return for that matter. But you're here for the appreciation as well on a long run, and hence it's important that you stick around for a long duration. And that's very important. So if you're looking at exiting in a 1 year, 2 year, 3 year mindset, please, it's a humble request not to consider investing on a platform, because we will not do justice to your investment, because somebody else who will eventually buy you out will enjoy the appreciation by sticking for a shorter duration instead of a longer duration as such. Okay, we have a question from Mr. Dheeraj. In case of a black swan event, how is an investor protected if the value of the property drops? Again, what Smruthi mentioned, so you're end of the day investing in a real estate itself. So that is a risk which is associated. But again, as an asset manager, we would take care of the best of interest to take care of leasing it if the event, the tenant leaves in a black swan event or anything for that matter. But you're still buying into the asset, just that you're buying it through the SPV itself. So all the perils, risks, and merits which is there by buying a real estate, just that we're mitigating a lot through our platform, whether it's tenancy risk or title risk or whatever, because we have our team, we take care of everything, we use the best of best law firms to handle. But having said that, that is a risk which always exists on any investments you make in real estate in general. Okay, we have a question from Mr. Hitesh. Do you have tie-ups with any big builders to invest in under construction properties at discounted price? We are, as we speak, evaluating one such opportunity. In fact, evaluating two such opportunities where we would be looking at investing at an under construction risk. Again, as a platform, we're very conservative. We don't want to take a very, very large risk, but we are seeing that, okay, if there's only 6 months to 11 months pending in a large commercial office complex, can we take that risk at a discounted value? Yes, that is something which we are actively looking at for our investors. Again, we have investors with all risk appetites. We're doing, in fact, we're rolling out a debt product also very soon. So that way you can leverage your investments as well at the same time.
There is time for one last question, I believe, Sudarshan.
Yeah, please go ahead.
We have Nandini, who has asked us, thank you for explaining the exit. Since the process at the end is democratic, do we continue to stay invested till at least majority of shareholders vote in favor? Like we answered a related question, Nandini, where there are various options for you to exit. One of them is yes, you stay invested till at least majority of shareholders have voted in favor. Otherwise, there would be an individual exit at your level and you could sell off your securities.
All right. I think I can probably take a last question and we can end this thing as such. So I think we've got a lot of questions. In fact, 3 common questions on: are you looking at assets beyond office and industrial and warehousing as such? Yes, we are. We are actively pursuing a hotel asset where investors can invest with the most marquee hotel name in India as such, the biggest, in fact, for that matter. Something which we are exploring. That is something which can come very, very soon. We're just trying to understand the risks and rewards for that investment and how to position it back to you. That's one. We're looking at hospital assets. Again, fantastic asset class. For 30 years, you get these lock-in leases from them. And such assets typically, with backed by good groups, whether it's a Manipal or an Apollo, etc., great investments for one to make, because it can be a legacy investment which you can keep holding on to and pass it on to your next generation itself. Right? That's the kind of an investment which you can consider doing for those kind of assets as such. But yes, we are evaluating retail, data centers, etc. as well, and these are certain opportunities which would be coming. So the whole idea at Strata as such was we wanted investors to diversify their investments, not just in different markets with different tenant industries, but also across different types of assets, which is also very critical, right? So you are making yourself to some extent recession proof. Would definitely not recommend anybody to put all your money into one asset with us. Please do come with a first long-term mindset and look at diversifying and creating a portfolio. We are here to serve you and evaluate the best of best opportunities and keep coming back to you. Right, in the interest of time, everybody, thank you so much all for joining. I hope it was an informative session and we answered most of your queries. In case you still have any further queries, feel free to write us at hello@strataprop.com, and Smruthi and I would take care of and reply back to you as soon as possible. Great, thank you so much, everyone. Thank you, Smruthi, for doing this.
Thanks, Sudarshan.